remotely. Most important development problem. Also because it affects support schools.
Good morning, good afternoon, good evening to everyone. Welcome to this panel on the challenge of globalizing private international law. My name is Ron Brand. I'm a professor at the University of Pittsburgh. I am a co-moderator for this panel along with Professor Louise Ellen Teitz from Roger Williams Law School. As we begin, I have been asked first to share the screen and the CLE credit information for those of you who are logged on who are wanting continuing legal education credit for this program. You need to write down the code number 434624 so that you will have that. You will then need to add that at the end by logging on to the website ILW at ila-americanbranch.org, complete the form and submitting it. So again, the code is 434624. Please write down that code so that you will have it. You will not be able to receive CLE credit unless you submit your form with that code. Okay. We have 60 minutes instead of the usual 90 minutes for this panel. We have a wonderful panel that's able to join us from many places today. I'm going to briefly introduce them. There is additional bio information on the CLE page that is available for this panel because there is CLE credit. But we have the principal institutions in which the United States participates in the negotiation of private international law and international private law instruments throughout the world. Three global institutions, one Western Hemisphere institution, and we also have the Assistant Legal Advisor for Private International Law for the U.S. State Department to talk to us. So we have from the Organization of American States, Western Hemisphere, Jeanette Trammell, who is Senior Legal Officer at the OAS. From the United Nations Commission on International Trade Law, UNCITRAL, we have Angelo Estrada Faria, who is the Principal Legal Officer and Head of the Legislative Branch. He's also prior Secretary General of UNITWA. From the International Institute for the Unification of Private Law, UNITWA, we have Anna Veneciano, the Deputy Secretary General. And from the Hague Conference on Private International Law, we have the Secretary General, Christoph Bernasconi. And as I mentioned, we also have from the U.S. Department of State, Office of Private International Law within the Office of the Legal Advisor, the Assistant Legal Advisor, Shubha Sastry. So it's a wonderful group that we have with us. We're not going to do a panel in which each person spends a certain amount of time speaking or reading a paper. We're going to try to have a substantive discussion here, and we're going to do it in by setting out a set of 4 questions and having each of the panelists respond to those 4 questions based on what is happening, what has happened, what's going to happen in their respective institutions. So our first question is, what is the most important development at your institution in the past year? And I'm going to go first to Anna Veneciano from UNITWA to bring us up to date on a little bit on UNITWA and what's happening there. Anna?
Thank you very much. Thank you, Ron and Louise. I'm mindful of the short time at disposal, but I would like to say that I'm really honored and delighted to share the panel with so many good friends and colleagues. I must say that it's difficult to answer this question this year because it was a particularly fruitful one for UNIDRA. We found ourselves at the end of a work program cycle with the approval of a number of instruments and then the beginning of a new one with new projects. So let me just mention 2 of the instruments that we approved in 2020 that I think might be interesting for the students. We have approved the Tripartite Legal Guide, which is a project of the 3 secretariats of UNCITRAL, HCCH, and UNIDRA to better understand the interaction between our respective instruments in the field of contract law. And we also mentioned the work done by the OAS in this respect. We have also approved an instrument in the field of agricultural law and development, the so-called ALEC guide, a legal guide on agricultural investment contracts. And this was done together with FAO and IFAD. But if I have to single out one instrument, that would be certainly the MAC, the Mining, Agricultural and Construction Equipment Protocol to the Cape Town Convention. Why? Well, because it's not every day that an international intergovernmental organizations negotiates and approves, adopts a treaty. I think last year was particularly fruitful for many of the organizations sitting here in this respect. It was, and it's well on its way to be a very successful instrument. We have the signatures of 5 states, despite the difficult times, and we are particularly honored to have received the signature of the United States very recently. So what does this treaty do? It is part of the successful Cape Town Convention system and provides for an international legal framework to protect creditors' rights worldwide. This facilitates financing for the acquisition and use of high-value equipment in three strategic sectors: mining, agriculture, and construction, which are extremely important, especially for developing economies. And let's think of a post-COVID scenario where you need to boost economies, but they're also important for exporting economies. So it's a kind of win-win situation. And it's not just us saying this, because we had independent economic assessment reports which were made for MAC and conservatively predicted a positive impact of $23 billion on GDP in developing countries alone. And if we look at the success of the aircraft protocol to the convention, we can predict an even greater success of this particular protocol because of the width of its application. So if I have to choose one, well, it would be, I think, the MAC protocol. Thank you.
Sorry about that. Thank you, Anna. We'll move from UNIDROIT in Rome to UNCITRAL in Vienna. Angelo?
Thank you very much, Ron. And like Anna, I'm also very pleased to be here and meeting again so many good friends for this occasion, which we try never to miss. Now, like Anna, this last year was a busy year for UNCITRAL. I mean, you know, we have always 6 working groups going on. So every year we're bringing a project to completion, and it's hard to single out one particular one. Last year we adopted the revised version of the UNCITRAL Legislative Guide on Public-Private Partnerships. It's a document that we had originally adopted in the year 2001. We also adopted notes on cloud computing to guide parties in negotiation of cloud computing contracts. And we also adopted an instrument on secure transactions. But perhaps the most significant event for us was last year, the signature and entry into force of the UN Convention on International Settlement Agreements resulting from mediation. 46 states, including the United States, signed that convention at a ceremony in Singapore on August 7, 2019. That's why the convention is known as Singapore Convention. 7 more states have signed the convention since, and the convention entered into force on September 12th, 2020. That convention had been adopted in 2018 after 3 years of very intense negotiations in which the US actually took a very active, if not a leading role. This convention complements the series of UNCITRAL instruments in the area of dispute settlement, and in particular mediation. We know that mediation is widely used in diplomacy. It's also referred to in Article 33 of the UN Charter, but is not that often used in the Western world for the settlement of commercial disputes. I mean, we would culturally favor more adversarial procedures like court litigation or arbitration, but mediation is very deeply ingrained in the Eastern culture. And that's why we had the strong support also from countries in that part of the world to the negotiation of this convention. What it does, it is inspired on the model of the extremely successful New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. The New York Convention has been ratified by 163 states and provides the basis for the functioning of the dispute settlement mechanism worldwide. And the idea here is to simulate, so to speak, the same effect also for mediation, so that when parties come to a deal at the end of the mediation process, they have the confidence that that settlement would be enforceable in all the countries that have ratified the convention. So that is a significant contribution to dispute settlement worldwide, and we're very proud of that development. Thank you.
Thank you, Angelo. So we'll go then from Vienna to The Hague. And Christoph, can you fill us in on the Hague Conference, HCCH? You are muted, Christoph.
Sorry about this. Thank you for the kind invitation, and pleasure to join you all, albeit remotely, and to see so many good friends and colleagues. The most important development at the HCCH, well, noting the use of the singular in your question, and after some internal deliberations, I have opted for the recent adoption of the explanatory report on the 2019 Judgments Convention. For two basic reasons. First, it is truly an important document and significant achievement. And secondly, it gives me the opportunity, of course, to talk about the 2019 Judgments Convention, despite the fact that it was adopted in July 2019, that is more than 12 months ago and before last year's panel. But the adoption of this convention remains a momentous event that should be part of any private international law panel these days. The Judgments Convention, of course, provides a common framework for the recognition and enforcement of foreign judgments in civil or commercial matters. It provides legal certainty and predictability as to whether and to what extent a judgment rendered by a court in one contracting state will be recognized and enforced in another contracting state. The convention provides for a floor rather than a ceiling for recognition and enforcement. It does not prevent the recognition or enforcement of foreign judgments under national law, except for judgments that ruled on rights in rem in immovable property. But I truly believe that this convention is a potential game changer. For the first time, a representative number of states from around the world came together and agreed by consensus on a common framework for the cross-border circulation of judgments in civil or commercial matters. The convention is important not just because it provides for effective access to justice, but also because it effectively supports cross-border trade and commerce by providing legal certainty and predictability to commercial operators. Now, one of, if not the most important tool to assist with the promotion of the convention, its implementation, and eventually its practical operation, including its uniform interpretation, well, of course, is the explanatory report. The explanatory report was prepared by two wonderful co-rapporteurs, Professor Francisco Garcia-Martin from Spain and Professor Geneviève Sommier from Canada, with the assistance of the Permanent Bureau, the Secretariat of the HCCH, which kept liaising with the members throughout the preparation of the report, which was also quite important. The report was submitted to the members of the HCCH for approval and in form of a 2-month silent approval procedure, during which no member raised a single objection. And I think that this smooth and swift approval of the explanatory report not only is a testament to the quality of the work done by the co-rapporteurs, it also demonstrates the keen interest of our members in this crucial instrument in the field of cross-border dispute resolution. The explanatory report, of course, is non-binding, but it provides the most authoritative guidance in relation to the convention, and it is, of course, available on our website at hcch.net. The convention has been signed by Uruguay and Ukraine. Public consultations took place in Brazil and in the European Union. They are now being followed by an economic impact assessment. These things follow the usual track. Mexico is conducting official consultations. Earlier this week, we learned that in Russia, the Ministries of Justice, Foreign Affairs, and the Supreme Court proposed to the government to sign the convention. There are efforts in the Western Balkans to join the convention, and needless to say that we hope, of course, that the United States of America is also actively looking into the convention. There clearly is momentum, and we hope to report more positive news at next year's panel. Thank you.
Thank you, Christoph. So now we move from afternoon in Europe to morning in America. And Jeanette, let us know what's happening at the OAS.
Yes, thank you very much, Ron. And I too, like the others, would like to thank you and Luis and the organizers for the invitation to this panel. And also it's a pleasure to be with friends and colleagues from around the world. I think for me, this question is a little easier because the one topic that comes front and center would be the project entitled Domestic Procedures for the Recognition and Enforcement of Foreign Judgments. So in the essence, in the interests of time, I would refer the audience to the excerpt that was distributed, which provides some of the context and background for this topic. In 2017, this topic was added onto the agenda of the Inter-American Juridical Committee. And for those who don't know, at the OAS, at the Organization of American States, this committee is similar to the International Law Commission at the UN in terms of serving as a legal advisory, legal advisory body. So 3 reports had been submitted by the rapporteur on this topic in the last years. And then in 2020, in August, at the committee's meeting, a 4th report with draft recommendations has been submitted. So these draft recommendations are under development, and we hope very much to be able to circulate those for comment and further input. So as Christoph had mentioned, the Hague Convention of 2019 on the recognition and enforcement of foreign judgments is such a game changer. And so this project, of course, makes reference to that and supports and wants to be consistent with these, the intention is to be consistent with these principles. It's not to duplicate or try to, the intention here is to really build on that convention. That convention, as well in Article 13, defers the matter of procedure to the law of the requested state. Similarly, the regional instrument, the Montevideo Convention, and the Inter-American Convention on Executorial Validity of Foreign Judgments in Article 6 does the same thing. So both of these instruments essentially refer the matter of domestic procedure to the individual states. And so the intention of these recommendations is to pick up from that point and to go forward. As many will know, the problem in Latin America is that there are multiple formalities. It's common for many internal regulations to require executor or other judicial proceedings, and that seems to really hamper things. So this project will bring the topic of the importance of recognition and enforcement of foreign judgments to member states to encourage reforms and modernization of these internal procedures to make the connection with international instruments on the subject more relevant. So we're also, of course, aware of the current work of UNIDROIT on enforcement and seek to ensure consistency with that instrument as well. So I think this is one example of how regional and international organizations can work together on similar topics to support and further the development of private international law. Thank you.
Thank you, Jeanette. So now we turn to Shubha Sastry at the State Department, who in a very productive year in these organizations has had to coordinate the US involvement in all of this. So Shubha?
Thanks, Ron. And I'd like to join the others in thanking the organizers of this and you and Louise Ellen for moderating the panel and inviting me to speak. It's great to be here. I also struggled a little bit with the singular, the use of the singular development in the question. So I'm going to report on 3 developments on the US side in relation to PIL instruments, some of which have already been previewed by my colleagues. But the first is the US ratification of the UN Receivables Convention, which was negotiated under the auspices of UNCITRAL. And for those who are not aware, is intended to facilitate international trade through increased access to lower cost credit. And that one was, we deposited our instrument of ratification sort of just under the wire just about a year ago at this time last year. So that was a pretty significant development for us in terms of becoming a party to that treaty. And then, as Angelo mentioned, we signed the Singapore Convention. That was a little outside of the 12 months, but we thought it was worth mentioning as a pretty significant development. We were one of the original proponents of that idea. And as Angelo said, have prioritized it as something that we thought was a useful project. And we were happy to see it come to a conclusion and to be able to sign. And then finally, both the conclusion of the MAC protocol in November of last year and then the US signature just hot off the presses on October 1st was another development on the US side that we were able to sign and to see that come to a conclusion as well. So that was a good development on our end. Thank you.
Thank you, Shubha. Lots of development with new instruments, but with all of these organizations, there's not just the development of new instruments, but the need to deal with existing instruments and to nurture them and develop them and make sure they're working well. So let's turn to that as to each institution. And Jeanette, if we can start with you on this one, on the OAS. And
yes, thank you very much. So here I had a little bit more of a challenge. I'll try to be quick. I have 4 topics I would like to address. The first one would be in the area of international commercial contracts. In 2019, the Inter-American Juridical Committee had approved the guide on the law applicable to international commercial contracts, and the General Assembly had issued the mandate to disseminate this guide as widely as possible. Excuse me. So in addition to efforts by the Secretariat to disseminate this guide, we see that it's being referenced increasingly at events and in publications, which is good news. It's being referred to in reform efforts by member states in their reforms to private international law legislation. And a very interesting development I'd like to mention here in relation to the COVID pandemic. The Hispanic American Institute for International Law, or ILADI, had adopted recommendations in relation to COVID and frustration of international contracts. And in the context of that recommendation, they do encourage the consideration of the OAS guide and its 18 recommendations that has the objective to strengthen the progressive harmonization on the law of international contracts. So we're pleased to see reference to the guide in that ILADI recommendation. Of course, they do also refer to other documents of our sister organizations, that we need to adopt principles, the recent tripartite guide that's mentioned, but this was very encouraging. Secondly, on the topic of warehouse receipts, in 2016, the Inter-American Juridical Committee had approved draft principles in this area and recommended that they be approved. In turn, the OAS General Assembly asked the committee to further develop these principles, but this work was held in abeyance because we knew that there was a decision pending. And now that UNIDROIT and UNCITRAL have decided to take up that topic, to go forward with it, our work essentially on this will be done, but we will be happy to continue to participate in the work as an observer and contribute how we may. But it's again an example of how regional organizations and international can serve to support the work of each other. The third topic would be on simplified business startup. The model on the simplified corporation was noted by the General Assembly in 2017. We did a draft report on the developments in member states on that was submitted to the committee this year. It's currently still in draft form, but we hope to be able to send that around to member states for their comments and then make that public. We continue to follow the work of UNCITRAL Working Group 1 on this topic because of the similarities and the objectives that we have in common there. Fourthly, on the topic of secure transactions, the model law there of 2002 was approved, and after 5 years of work, we finally were able to complete a publication in collaboration with the University of Cadiz, and that publication, part 1 of that, is essentially an annotated version of the model law, and then part 2 also includes reports on the progress of member states in their reforms on secure transactions. Sadly, that work was just published before the pandemic, and unfortunately the books are trapped and we are unable to distribute it, but we hope to be able to do so. So that very quickly would be a snapshot on 4 topics and the developments in the last year. Thank you.
Thank you, Jeanette. And then we'll move back and let's go to the Hague Conference. Christoph?
Thank you, Ron. And here I have opted as the main issue for the impact of the COVID-19 pandemic on the practical operation of the 1980 Child Abduction Convention, which, by the way, will celebrate its 40th anniversary this Sunday. This convention, of course, is designed to protect children from the harmful effects of cross-border parental abductions by providing a procedure for the prompt return of an abducted child to his or her state of habitual residence. Now, various effects of the pandemic have had and continue to have an impact on the operation of the convention. Take the closure of borders, the cancellation of flights, restrictions on movement. This meant that return orders could not be implemented. As a result, some judges started refusing return requests or including vague instructions in return orders. For example, that the return needed to be effected only when the situation was safe, whatever that means. The closure of courts. In some jurisdictions, courts were entirely closed and it was not possible to hear return applications. This led to a massive backlog of return applications. In some jurisdictions, hearing abduction cases was considered to be an essential service and allowed to continue. The reduction of other public services due to government restrictions. This led to a reduction in some jurisdictions of the efficiency and services rendered by central authorities under the convention, severely impacting its operation. This included, for example, no guarantee that preventive measures could be implemented and practical arrangements may have been aborted or not put in place. Another issue was that due to the reduction of public services, access to legal aid or pro bono services was severely curtailed, leading to difficulties for the left behind parent trying to file a return application. As the situation dragged on, there was also worry that the 1-year limitation would be exceeded. The rising tensions and heightened allegations of abduction. In some cases, the alleged taking parent simply could not return for very practical basic reasons with the child. And there was then accusations of wrongfully retaining the child abroad. So you see a whole series of very practical, important implications. What have we at the Permanent Bureau done to support the Convention's continuing efficiency nonetheless? Well, we have published a toolkit for the Child Abduction Convention in times of COVID-19. It was first published on the 3rd of July and updated on the 6th of October. The toolkit aims to help ensure that the Convention continues to be effectively applied in times of COVID-19 through contact and cooperation with and the sharing of resources between central authorities. There was significant consultation between the PB and central authorities, judges and practitioners in order to arrive at a toolkit that is practical and feasible and that addresses salient issues due to COVID-19. We, of course, also promoted the recently adopted Guide to Good Practice on Article 13.1b, which is a provision that sets out one of the exceptions to the prompt return of the child under the Convention, the so-called grave risk exception, including where a return would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation. The specific sections in the guide, which was published in March 2020, very timely indeed. So the sections in the guides relating to practical arrangements and the practical application of the exception where there is a risk due to a medical condition of a child or where the taking parent is unable or unwilling to return with the child to the state of habitual residence are, of course, of particular relevance. Finally, we facilitated informal consultations among central authorities and among the judges of the International Hague Network of Judges, often through regional video conference roundtables to share experiences and best practices about coping with COVID-19. Thank you.
Thank you, Christoph. And so back to Vienna and Angelo.
Thank you, Ron. Again, it's kind of difficult to single out only a few of our instruments, and I think COVID also overshadowed most of what happened last year, and we are not an exception to that. But let me begin by a positive note, and that is this year also we're celebrating, like the Hague Conference, we celebrate an anniversary. We also have one anniversary. Here is the 40th anniversary of the UN Convention on Control for the International Sale of Goods, the CISG. This ISG entered into force in 1988, and as you know, significantly with the ratifications by China and the United States, also Italy also ratified at the same time. Now the CISG is in force in 94 countries. Most recently, Portugal adopted it, meaning that nearly the whole of Europe, apart from the UK, Ireland, and Malta, the whole of Europe has already ratified the CISG. So that is a positive thing for us to celebrate. But inevitably, as I said, COVID-19 was the event that had the most impact in our instruments. And just to give you a few examples, the pandemic has caused, as you all know, a gigantic disruption in supply chains and logistics around the world. And this is likely to lead to a significant increase in trade-related disputes for either breach of contract or delayed performance. This is just unavoidable. We see this coming down the road. And in relation to the CISG, there is a wide consensus that the fact that you have a worldwide instrument that provides a uniform standard for force majeure and hardship is very positive in terms of enhancing predictability for the outcome of these disputes that are about to come. But the pandemic has also shown the shortcomings of existing outdated legislation in many countries, and that has led, for instance, the International Chamber of Commerce to start a high-level political initiative to motivate governments to enable paperless trade. Because in these days of social distancing, these days of lockdown, transactions just could not take place and be done the way they used to before, and in particular when it comes to trade financing through letters of credit and documentary credit. So the ICC is calling governments to implement UNCITRAL standards on electronic commerce, the model law on electronic commerce, the model law on signatures, the most recent model law on electronic transfer of records, and also the UN Convention use of electronic communications for international trade. So we see that there will be a boost for governments to equip themselves with the legal norms that they need to facilitate trade, especially paperless trade. But you also see some developments that are worrisome. We see in the area of procurement, where we also have work that at the one hand, there is a movement towards enhanced digital procurement. There are concerns about stockpiling becoming an alternative to emergency procurement, and showing that governments perhaps don't have adequate rules for public procurement. And again, the relevance of the UNCITRAL model law. The same also applies to the area of public-private partnerships, PPP. Also here, UNCITRAL has developed standards. Governments are going to face not only their incurring huge debts to support the economy through the pandemic, but they also would have then difficulty expanding services the way they've used to in the past. They would have to use more and more PPPs, and existing contracts also be affected by increased costs through the pandemic. And here, a framework like ours would be particularly significant. Last but not least, another positive message with feedback we got from industry was that the UNCITRAL instruments on dispute resolution, be they the New York Convention or the model law on international commercial arbitration or the arbitration rules, have scored very well in the pandemic in terms of their flexibility to accommodate a significant shift towards online and digital use of digital technology, online hearings, and the use of online platforms, but also calling our attention to what we need to do also in the future to facilitate this further. For example, by increased use of AI and other technologies to facilitate dispute settlement. So it's a trend that is being pushed by the pandemic, and it's here to stay. Thank you.
Thank you, Angelo. Back to Anna in Rome.
Thank you, Ron. And allow me to join my colleagues in mentioning one anniversary, which is the 25th anniversary of the UNIDROIT Convention on Stolen and Illegally Exported Cultural Objects, which was celebrated at a conference that we held 1 month ago here in Rome. But I would like to focus, just like Jeanette and Angelo did, on our instruments on contract law in particular, because the most novel implementation work we did regards the evaluation of how our existing contract law instruments can offer guidance to counteract those contractual disruptions arising from the COVID-19 pandemics and the governmental measures deriving from it, which were also already mentioned by my colleagues. And we have issued a specific secretariat note on the UNIDROIT principles on international commercial contracts, looking at how its modern and flexible provisions on force majeure and especially on hardship, which have already been enormously influential in the domestic and international context, can help legislators or adjudicators to rethink traditional domestic law provisions on supervening events, as well as help parties to solve pending issues or to draft reasonable clauses for the future. So this is, of course, it's a soft law, it's a tool which can be used by different stakeholders, and you can find the note on our website. We are also looking at our contractual instruments in the field of agriculture, and in particular the UNIDROIT FAO IFAD Legal Guide on Contract Farming, which is a guidance document for agricultural production under contract. And I believe that in this area, COVID-19 has strengthened the importance of a risk sharing and cooperation culture in this kind of relational contract, which is exactly what the guide fosters, both for the content of the contract and also in dispute resolution. So I come back to the dispute resolution issues that were mentioned by my colleagues, and I think we really are discussing similar issues, and I'm very happy that this is an ongoing discussion in many organizations. Thank you very much.
Thank you, Anna. Once again, Shubha, a lot to cover. How do you boil that down in terms of what the United States what's happening at the State Department to monitor all of this?
So I was going to go in the direction of reporting on a couple of Supreme Court cases that have come down in the past year that address private international law instruments that are important on our end in terms of how the U.S. is approaching these instruments. So the first one is the GE Power versus Outokumpu case, which I hopefully I pronounced correctly. That is a case that deals with the New York Convention on enforcement of recognition and enforcement of arbitration agreements, of course. Excuse me. And there was a sort of complicated contractual arrangement in that case, but the issue was whether an entity that was not a party to the contract at issue, but was relying on it, could, whether the arbitration clause in that contract could be enforced against that entity under the theory of equitable estoppel, which is a common law principle that arose under the relevant state law in that case. And what the Supreme Court found was, which was consistent with the amicus brief that the United States government had filed, was that that particular set of facts was not specifically addressed by the New York Convention, but that the New York Convention did not preclude the enforcement of arbitration agreements where domestic law provided for more generous enforcement of those clauses. And so that was, we thought, an important case addressing an instrument that is, a pretty core private international law instrument. And then the other one was, speaking of the abduction convention, which Christoph mentioned, we had the Monaschi versus Taglieri Supreme Court case, which was decided in February, and was looking at how to determine a child's habitual residence under the Hague Abduction Convention. The Supreme Court concluded that it should be determined based on a totality of the circumstances standard. In that case, there was also a question of whether there needed to be an agreement between the parents regarding the habitual residence, and the court found that there did not need to be such an agreement, but that it was the totality of the circumstances or standard that governed. And so that was another important development on our end in the interpretation and application of these instruments. Thanks.
Thank you, Shubha. I'm going to turn matters over now to Louise Ellen to move us forward to the future.
And in some ways, this is a flip side to the last question, which is what are the most interesting projects on the horizon at your institution? And there's an S, so you can talk about more than one. And I think we'll start first in The Hague with Christoph.
Thank you, Louise Ellen. And I will be using the plural here and first talk about the jurisdiction project. The jurisdiction project, of course, can be seen as an extension of or a complement to the Judgments Convention and indeed the 2005 Joseph Court Convention. The mandate here is to explore the possibility of developing a convention or other global instrument to establish direct grounds of jurisdiction in cross-border civil or commercial matters. The discussions on this project had been put aside temporarily to allow us to focus on and finalize the Judgments Convention, but the experts group on jurisdiction resumed its discussions in February, just before the pandemic hit. At this third meeting, then the group discussed the desirability, necessity, and feasibility of preparing an instrument on matters relating to jurisdiction, including parallel proceedings and related actions or claims in court-to-court cases. In this context, it explored the question of cross-border cooperation between courts of contracting states to overcome the challenge of or challenges of parallel proceedings. Following that meeting, CGAP, our governing council, the Council on General Affairs and Policy, mandated the experts group to continue its work and to assist with group discussions. We at the PB circulated a questionnaire on parallel proceedings and related actions, and the findings are currently being finalized. The basic elements of a possible new instrument with rules for parallel proceedings are currently being discussed. Again, we are at experts level, and so obviously no decision has been taken whatsoever. But I'm really encouraged by the engagement of experts and their willingness to discuss possible options involving consultation amongst judges seized, the possibility of a transfer of jurisdiction. Even forum non-convenience is being considered and discussed as a possible corrective tool when assessing the applicability of a direct ground of jurisdiction in a particular case, or indeed as a tool to overcome the challenges of parallel proceedings. The group will meet twice before the next CGAP meeting in March 2021. One meeting of the experts group will take place in the week in mid-November, and then another one again in February of next year. The other project is the so-called PISA project, the Parentage and International Surrogacy Arrangements project. Here the mandate is to explore the feasibility of developing a treaty or treaties on private international law rules regarding the legal parentage in cross-border situations, including when legal parentage is established as a result of an international surrogacy arrangement. How do we do this? Well, the experts group is basically focusing on developing possible provisions for a general private international law instrument on legal parentage, the convention, and a separate protocol on legal parentage established as a result of an international surrogacy arrangement. As regards the convention, the experts group agreed on the feasibility of rules on the recognition of foreign judgments on legal parentage. It is still discussing the feasibility of applicable law rules relating to parentage and rules on the acceptance of legal parentage when recorded in a public document, which of course is especially relevant when legal parentage is not established by a judgment. In the protocol, discussions are mostly around the feasibility of the following points: the inclusion of the recognition of legal parentage established as a result of an ISA, an international surrogacy arrangement, by any method, that is not only by judgments, but indeed by any method. The role of safeguards in this regard, should such safeguards be conditions for recognition, or should they be a general obligation when entering in international surrogacy arrangements? The time of their verification, before the child is conceived or after the child is born, the level of details needed, and so on and so forth. Again, we are at experts level, and as you can imagine, international surrogacy arrangement, well, is a very delicate topic, in relation to which states take quite different, often opposing legal, societal, and policy views. I should also say that this project is not to condemn or support surrogacy, but rather to find consensus-based solutions in relation to parentage, taking into account the best interest of the child. Thank you.
Thank you, Christoph. Let's move to Rome and Unidwa, Anna.
Thank you, Louise. And we have a very rich new program, and I have to curb my enthusiasm in this respect because we don't have much time. So I will just mention the project and then refer back to the document that we shared with the students for more information. But let me say that as a general statement, all new projects generally aim at improving access to credit, also for smaller enterprises, some of them with a special focus on the agricultural sector, and all projects that will consider the impact of new technologies on the law. So those are the general elements of the projects. What are they? We will work on 2 model laws. A model law on factoring, again, access to credit. The model law on warehouse receipts that was already mentioned by Jeanette. And this is our joint project together with Ancitral. We are really looking forward to it. It is a very specialized but extremely important field of law. We also will be working on 3 guidance documents in sectors where it was felt that there was a lack of a global international best practice guidance. One will be the best practices on enforcement on that phase of the execution of creditors' rights, which is so difficult in many jurisdictions. And I think, again, Jeanette mentioned this project. Another project dealing with the development of technology is the digital assets and private law project. We started work on this big area together with Ancitral on a taxonomy, and now we have an independent UNIDROIT project focusing on the private law aspects of transactions involving digital assets. And just to conclude, we will also have a project on the legal structure of agricultural enterprises, which will have points in common with many of the areas of the law that are touched upon by our sister organizations and other international intergovernmental organizations. So I hope students will be interested in this project and have a look at our website. Thank you.
Thank you. And now to Vienna. Angelo.
Thank you, Louise. Again, like Anna, I would invite also the students and other attendees to visit our website, because it's very hard now to summarize within 3 minutes what the 6 working groups of Ancitral are currently doing. As you know, we're a rather large organization, but very quickly, working group 1 is developing standards for a simplified limited liability organization structure for micro, small, and medium enterprises. Working group 2 is working on a possible addition to the Ancitral arbitration rules for dealing with expedited arbitration. Working group 3, I would talk about that in a moment. Working group 4 is, which is currently meeting in Vienna, is developing a model law on electronic identity management and trust services. This again to support the development of the digital economy. Working Group 5 is currently, that has extensive work in the past on insolvency law, is currently working on a specific regime for insolvency of small and medium enterprises. And Working Group 6, which has in the past developed our standards in the model law on secure transactions, is currently working on a new international convention on judicial sale of ships. This is a very specific topic. Now, what are the most interesting projects and the horizon? Yes, let's then refer to the projects that are at relatively early stage, and that is the work of Working Group 3 of UNCITRAL. This is the project that attracts most attention by states, IGOs, and NGOs. And it deals with the possible reform of the current system of investor-state dispute settlement. Just to give an idea of how much attention this attracts, when the working group met from 5 to 9 October, we had 1,000 registered participants participating, and most of it are just large government delegations. So it's a very topical issue, and one also where building consensus is not very easy. So the working group has completed the first 2 stages of its mandate, which were basically taking stock of the situation, of the criticism that has been expressed against the current system of investor-state dispute settlement, and is now in the process of considering possible reforms that UNCITRAL could contribute to bring about to address the criticism that has been expressed concerning the current system. And they deal with things like, for instance, develop a code of conduct for adjudicators in investor-state disputes, for regulating third-party funding in investor-state disputes. The idea of that some countries favor of developing a sort of a standard appellate mechanism, or some even would like to see an international court for dealing with investor-state disputes, and also mechanisms for the selection of appointment of members of tribunals in investor-state dispute settlement. There are several other options also that are included in the work program of the working group concerning, for instance, ensuring consistent interpretation of standards in investments treatment, for example, fair treatment, and the non-expropriation clause. How can this be interpreted in a consistent way in different treaties? How to deal with the issue of shareholder claims and reflective loss in claims against states, and how these various options could become workable in a system where we have more than 3,000 investment treaties around the world. So how can we, from the perspective of treaty law, make this work? So this is certainly the most challenging project we currently have at UNCITRAL, and the question is, how big could be our resources to deal with all of this in a reasonable time? Because this is only one working group of 6 meeting only for 2 weeks altogether in 1 year. But this is not the only interesting project we have. And look down at the horizon, we'll be also starting work on various legal aspects of the digital economy. Anna has alluded to some of them, including artificial intelligence, automated contracting, rights to the parties to data transactions, and also dispute resolution and online trading platforms. So you see, we can't complain about not being busy for the next few years. Thank you, Liz.
Thank you. It's amazing to hear how much everybody is doing. Jeanette, from this side of the pond, what's happening at the OAS?
Yes, thank you very much, Louise Ellen. Yes, we're busy too, even though our secretariat is quite a bit smaller. So our projects, we have a fewer number, but nevertheless, we're ambitious. So I would refer on this question to my response to the first one, which was on the topic of the judgments. So that is a work in progress. As I mentioned, the rapporteur had submitted her report with draft recommendations to the committee in August. This is on the domestic the domestic procedures for the recognition and enforcement of judgments. So we work, the Secretariat, for the students' benefit, the Secretariat works to support the work of the rapporteur, who has the main carriage of the topic. So we're hoping to see if we might be able to have a working group of experts virtually to see about looking at these recommendations and draft and moving that forward into the next meeting of the committee, which will be in 2021. So that is the project at the moment, which I would say is the most interesting, because it is such an important topic, as Christoph had mentioned, in terms of the Hague Convention, raising awareness of the importance of the domestic procedures and making the connection between this and the international instruments in this region would be very significant move forward. A second point I would make would be in relation to the guide on the law applicable to international commercial contracts. There we have been approached, the Secretariat has been approached by certain member states for technical assistance in the reform of legislation that would be consistent with the recommendations in the guide. So that is also something very interesting on the horizon. We continue to follow all the other topics and try our best to follow the work of other our sister organizations. So on the topic of warehouse receipts, of course, we're very interested in seeing the work of Ancetral and Unidroit going forward on that. So thank you very much.
Thank you. And Shuba, given how many projects they're all doing, and you have a tiny office to try to cover the breadth of all this work.
Yes, we do not suffer for work, but fortunately we enjoy it. So it's been a really exciting time to be joining the private international law world and figuring out where we are going to focus our energy. So I was going to highlight a couple of things that have been mentioned by others, so I will try not to repeat. I was going to highlight also the parentage and surrogacy project at the Hague Conference because it is sort of an interesting new area that is being explored. It raises a number of complex issues, and we are participating in the experts group in the hopes that progress can be made on the issues that are presented there. The other issue that I wanted to highlight was the digital, so-called digital economy, or those types of issues. We have noted the significant interest on the part of a number of organizations, not just in the private international law space, but even other organizations, OECD and others, to address these issues. And I think we always see a couple of challenges to figuring out how we focus our efforts on this area. The first, and perhaps everyone or almost everyone in this call has already heard me make some of these points, so it could be repetitive for some of you, but the first is that I think the development of new technology spurs a discussion of what we need to do to respond as a matter of legal instruments or legal rules. But I think sometimes we still have a question as to whether existing legal rules are sufficient to address the issues that are arising, even if it's just with the use of new technologies, or whether existing rules will simply apply in the digital realm, or whether new rules are in fact necessary. I do think some of that analysis is being done, for example, in the digital taxonomy project that Unidroit is undertaking, etc. And then the other challenge that we see with the digital assets or a digital economy realm is that it's such an evolving field at the national level. We see a number of countries grappling with what rules they should develop to address this area, where they do see the need for new rules, that we struggle with whether harmonization at the international level is whether it's the right time, whether it's feasible at this time, or whether we need to see sort of the dust settle a little bit more on national governments figuring out how to address these issues. So we see that as sort of one of the big areas on the horizon. There's a lot of demand to address it. Perhaps that demand is only increasing in light of COVID, and we are watching that space, and it's one of our areas of focus, but we do struggle with these sort of questions of what's the best way for the private international law world to plug into those issues. Thank you.
You're muted. Louise Ellen, you're on mute.
Sorry, I was struggling to find the unmute with the screen taken over by the CLE. But for our final question, we wanted to see how COVID-19 has affected the agenda and working methods in the past year of your institution and in terms of the horizon. Angelo, why don't we start with UNCITRAL?
Thank you. I was actually hoping that we would have started with someone else because this is such a sore issue for us. But let us begin by facing reality. At the beginning, at least, the pandemic, COVID-19 was a major disruption to our work from the perspective of working methods. You know, the UN is just like works like the World Parliament, but perhaps with even greater level of disagreement among the various representatives. So COVID-19 blocked our processes completely because countries could not meet, could not travel, could not sit together. And what happened, we are currently in a situation where there are meetings taking place in New York, but it's only the diplomatic personnel that participates in those meetings, so we cannot bring experts from the capitals. We have then to engage them by video conference, as we're doing now via Zoom. That is complicated by the UN, the fact that we have to do it in 6 languages, and using our internal interpreters makes the thing more complicated. But to add to that, also member states are reluctant to take decisions in virtual meetings. And they said we can only take decisions again in meetings in person when we meet again in person. So we are now bound to use a so-called silence procedure, which means that decisions are taken in writing outside the meetings by a process whereby if any country breaks the silence on a text, the text is not adopted. Now, with 193 member states, you think that can easily happen. So it makes our entire process much more difficult. We have to think strategically how we present possible decisions to member states and so on and so forth, so as to reduce as much as possible the risk that there would be a disagreement and blocking the process. That said, countries are themselves now more familiar with the process. Our technology is working better. Everybody's is got to accept that also maybe COVID is going to be longer around than we wish, and we have to make the best out of what we have. And now there is less suspicion about the way we can conduct our business, and it's been working fine. We had 5 intergovernmental meetings so far in this hybrid format, and it's working. And let's see how far this will continue. But it is improving. The beginning was tough, but it's getting better. Now it's also affecting our agenda, because this is what most governments are concerned with. And at the last Commission session, I had proposed new proposals for future work, as if what we already have on our plate was not enough. Countries then suggested that we have to address legal aspects of COVID. Some of them in a limited fashion. Israel proposed that we should develop a platform for countries to share their experiences with legislation related to COVID, both in terms of emergency reaction, but also recovery of the economy costs of COVID. Japan suggests that we focus also on analysis on how dispute settlement institutions have responded to COVID. But the Russian Federation has tabled a much more ambitious proposals, saying that we should look comprehensively at all measures taken by states and the extent to which they have disrupted international trade, And UNCITRAL should, after canvassing all this field and having a clear picture of the horizon, develop standards for governments to act in such emergency situations. Not only this one, but also in the future with the view to reduce as much as possible the disruption to international trade. So as you see, COVID has affected us in both ways, but we are learning with it. And I think also from a substantive point of view, any work that we do would also have a great learning effect also for all countries or governments around the world. And are much in favor of us doing something like this. Thank you.
Thank you. And Ron and I think we have problems trying to teach online. Christoph, from the Hague side, how has this impacted it?
Well, Angela has said a lot of the same things that we went through, although I have to say that we at the HCCH, we have been fortunate. Fortunate in the sense that our CGAP meeting, our council meeting, could be held in person during the first week of March, earlier this year. I think it was the last major event held in The Hague in person before the restrictions kicked in. We were also fortunate because about 2 years ago or so, we moved all our major IT operations to the cloud, which meant that from one day to the other, the Secretariat could continue to work remotely with colleagues just working from home and without any real difficulty. Of course, a number of meetings that were planned to take place in person after March, they all had to be moved online. And like everyone else, we learned and experienced how to do this. And I think we did pretty well given the circumstances. I think I can say in full confidence, actually, that overall the organization has remained and continues to be efficient and effective. And I think that's probably one of the advantages of being a small organization and to be able to adjust fairly easily and in a flexible way to a new reality. But we were also fortunate in the sense that, for example, in April 2020, we managed to publish a guide on a guide of good practice on the use of video link under the Evidence Convention. And so again, as you can imagine, that was very timely indeed and got quite a bit of visibility. The guide analyzes the latest developments and outlines good practices to be followed in the use of video link in the taking of evidence under the Evidence Convention. We also circulated 2 questionnaires on the use of IT in relation to both the service and evidence conventions. We are still going ahead with a plan to have what we call the abridged series, an abridged event in December to celebrate the golden 50th anniversary of the Evidence Convention. We continue, as you can imagine, to continue to promote very actively the issuance of electronic apostees, which got a lot of traction these past months, including, I'm very happy to say, in the US. A lot of offices of secretaries of states have contacted us and asked for information. How can we do this? We, by the way, also started to work on PIL issues relating to various aspects of the digital economy, a horizontal topic across all organizations represented here. On a complete different matter, we still managed to engage in meaningful discussions with international adoptees. So that relates to our inter-country adoption convention, to listen to their experiences, desires, queries, and to learn from them. And again, a lot of these things can be done online. And finally, more down to earth, earlier this week, our regional office in Hong Kong just moved into new premises, thanks to the generous support from the government of the People's Republic of China and Hong Kong. So things continue to operate. All this being said, though, we are obviously looking forward to seeing our experts and delegates again in person. I think that the process of international lawmaking can benefit from remote participation, in particular in terms of universality and inclusiveness, meaning that remote participation for a number of experts in different parts of the world is easier, cheaper, and indeed would not be possible if they had to travel and spend a week in person in The Hague or elsewhere. On the other hand, as regards, for example, the first meeting on the practical operation of our Child Support Convention of 2007, originally planned for December 2020, we just decided to postpone that meeting. And we consciously did not want to go online with that meeting because we considered, in consultation with our members, of course, that in-person contacts and discussions are absolutely essential for this particular meeting. So in conclusion, I think in the future, there will be more hybrid meetings, more people and experts and delegates will want to participate online, but in-person meetings will not disappear, absolutely not. And I'm confident that even in this new reality, the HCCH will continue to stand for effective, practical multilateralism that makes a real tangible difference in people's lives. Thank you.
Thank you. Jeanette, how has the OAS been dealing with this and how has COVID affected the agenda?
Yes, thank you very much, Louise Ellen. I would have to heartily agree with what has already been said there. That and for us too, I think almost all our meetings have been held virtually, including the meeting I mentioned in August of the Inter-American Juridical Committee. The OAS General Assembly, which usually meets in June, was deferred until October. In fact, it was just held this week, and it was all virtual as well. In so many ways, as Christoph has said, it makes the work more accessible. But I would like to just briefly quote here from an article that just came out by Sean Murphy in the ACIL Journal on COVID impact on the International Law Commission, where he says, require reading the room and understanding subtleties in position, which can be lost in a virtual environment. Likewise, resolution of differences on the margins of the formal meetings become more difficult. And so I wanted to just note that, because that's very true for us as well. And I think, as Christoph alluded to that, just that there's certain things about the in-person meetings which just can't be replaced virtually. Nonetheless, it's been wonderful because it's made our work more accessible to a number of people and awareness about our work. The Secretariat has been hosting a virtual forum until recently. It was every Monday at 11 a.m. on several topics, not just in private international law. Obviously, it was on all of our areas of work. These have been recorded, and then they can be viewed subsequently by students or other interested persons. And so this has expanded the awareness of the work. And in one of our meetings, which was on access to credit, in fact, we had Anna as one of our panelists, which we would never have been able to do otherwise. And so it has made the work much more accessible to more people. The Secretariat always participates in a conference every year of ACIDEEP, which is the Latin American Society for Private International Law. And that's usually held every November in a different country within the region. This year, for the first time, was to have been held in Washington, and now it's been deferred until 2020. But that organization has continued with virtual sessions as well on Fridays. So I would agree with what has been said. There are pros and cons, and we just move forward and continue with this work, which I think it has been demonstrated. The work of promoting private international law and international law generally overall has become more important more than ever. Thank you.
Thank you. And in Rome.
Thank you, Louise. Well, I also have to echo some of the things that have been said until now. I think that from the institutional side, we were fortunate because we are a very small and nimble organization, and we did not actually, we never stopped our work, and we organized one of the most important institutional sessions we have virtually, and then most of the other sessions as hybrid events, that was also mentioned, remotely and partly in person. One of the challenges was to ensure online interpretation, so we had to study this topic and we tried to find solutions. There were good aspects. One of them was already cited, the fact that workshops and conferences really reached out to a much wider public, also younger public that would not have been able to participate, and then recording the sessions. This makes for much more interactive and interesting material also to be posted and to be shared. There are negative sides. The ones we saw most were on the promotion and implementation of our instruments, because it's very difficult when you do not have in-person meetings, for example, with governments or with stakeholders and beneficiaries, let's say, of the of our instrument. So again, yes, I have to join my colleagues and friends in saying some interesting developments that will stay with us, that have introduced interesting novelties that we will continue to use, and then hoping to go back to some of those corridor talks that are so important in our work. Thank you.
Thank you. And Shubha, how has the State Department adopted to this, and what impact has it had?
So I will also, some of the points I wanted to make have also been echoed by others, so I will try not to be too repetitive, but I wholeheartedly agree with the point that Jeanette made, that you know, the way that we work through compromises and talk through issues with other delegations, it's not through formal interventions that you can do over a virtual platform. It's over coffee in the coffee break. And so we're missing that. We're trying to maximize the use of the technologies that are available, which are remarkable. There are always some technical glitches that arise, but for the most part, I would say all three of the organizations, and I haven't participated in an OAS meeting since the pandemic, since the quarantine began, but with the other three organizations where I have participated in the meetings, I would say there's been a tremendous job in making things run as smoothly as possible and to maximize participation of delegations under these difficult circumstances. So we're trying to make the most of it, but I would say that you definitely are missing out on something when you can't sit down over coffee or whatever, sit down in the break and have those sort of, you know, those conversations to work through issues. We also noted the proposals as a more substantive matter that have been made in UNCITRAL from Russia and Japan this year as part of the commission. And I think we may see more things along those lines, just in terms of how COVID has impacted economic activity and studying that. But I wanted to note the dispute resolution space in particular. So Japan has this proposal on a sort of a stock taking, but we see more innovation in dispute resolution to have online means for dispute resolution more and more, because COVID is creating a demand for that. Hong Kong has set up a new ODR mechanism, and there are some others. And so I expect that we may see COVID accelerate the demand and the innovation in that space. And then we may see some of those trends persist after COVID because of the additional flexibility that it allows. But I mean, it remains to be seen, but I think that's one area where we see an uptick in innovation and work. Thanks.
Well, I know we've run a lot over time, but I think everybody has gotten to see, I think, three important things. One, how much all of these entities are continuing to do and producing an amazing amount, how they all have this interconnection and work together, which is really wonderful to see that impact. And finally, I think we're seeing the benefits of the virtual world, because we would not be so lucky to have all of you in one room like this for an hour, as opposed to in the real world. So I'm hoping that we can do a serial repeat next year. And even if we're back to in person, those of you who can't be with us in person will be able to Zoom in, now that we know that hybrid technology works as well. And Ron and I want to thank all of you for giving your time and taking this opportunity to share with all of us. I know it's very unusual to have so many wonderful experts together at one time. So thank you very much. Ron, anything else?
Only to say thank you all, and not to take any more of anybody's time, but it's been a wonderful discussion. We very much appreciate your taking the time to be with us. Thank you.
Thank you.
Thank you very much.
Thank you.
Thank
It's
you.
been a pleasure.
you.
Thank you very
Bye-bye.
much.
A great
Thank you
pleasure.
for
Bye-bye.
organizing.
Thank you.
Thank
Thank
you.
you.
Bye-bye.
Bye.
Bye.
Bye.